Joe Norman, Tallahassee, Florida. I'm a victim of deeply embedded, widespread government corruption. Joe Norman, Tallahassee, Florida. Retired airline captain. I'm a victim of widespread government corruption. In 1989, the pilots of Eastern Airlines went on strike to support the International Association of Machinists who had previously struck. During the strike, Eastern hired replacement pilots. These pilots started in training with the intent of completing training, and upon completion of training, joining pilots who were continuing to fly Eastern aircraft. The reason for that was Eastern needed revenue to continue operation, so trainees were vitally important. ALPA, the Airline Pilots Association, who was on strike, established a program called the Pilot New Hire Program. Traditionally, when pilots are on strike and outside pilots cross the picket line, ALPA would establish a new hire program to establish a relationship with pilots in training and attempt to induce them to cross the line, come back and join the striking pilots. As an inducement, the pilots in training who left would receive strike benefits and membership standing as though they were a member in good standing of ALPA. They would not be considered scabs. Scab list is like a blacklist. And upon the successful conclusion of the strike, they would go back to work as though they were an established Eastern pilot with that group. I've never flown a plane for Eastern Airlines in my life. My name's on the scab list, and that's where the saga begins. After finding my name was on the scab list, I joined a group of pilots that were suing ALPA over the distribution and publication of the scab list. Having been an airline pilot at that time for more than 20 years, I knew what constituted a scab. I'd seen many strikes, and I knew as long as I didn't fly, I was in the clear. I did start training with Eastern. I did join the new hire program, and after I left, I entered into a contractual agreement with ALPA and immediately started receiving strike benefits like the striking pilots. I was giving membership cards showing I was a member in good standing, identification cards, attachments that showed me to be in good standing, and the list goes on and on. On one hand, the defendant was saying I'm a scab, my name's on a blacklist. On the other hand, I've got a ream of evidence that showed that legitimately I did not qualify as a scab. So having my name on a blacklist seriously imperiled my earnings ability. It reduced me to really the bottom of the aviation barrel. And I began litigation. The litigation began the court of Edward B. Davis. At a point in the proceedings, various defendants were deposed and commented on evidence that I had received. And I'll just run over a couple of examples, then we'll go into depositions. Now, depositions are sworn statements to be used to verify the credibility of evidence. The first one I'll review, and I'll show you. It's part of the one of the original district court filings. One is proof that I was receiving strike benefits. As of December 31, 1989, I'd received $18,120. As of December 31, 1990, I received another $4,067. The reason the amount of money was reduced in 1990 is because strike benefits ceased, I believe, at the end of February of 1990. Here are ALPA membership cards. One expired in 1991. I have attachments that were put on your employee identification card that says The bearer of this identification card is a striking Eastern Airlines pilot participating in a sympathy strike with Eastern Airlines International Association of Machinists. Now, the relevance of this, I'll provide commentary from one of the defendants in the case, Gregory Pachinko, who was one of the ringleaders, if you would. Let me take a pause here. Yeah, this is one of the front pages of the Gregory Pachinko deposition. It was attended by his two defendant attorneys representing Mr. Pachinko, one James L. Lindsay and the other Stuart Goldstein. Mr. Pachinko says, and here's the question, were you involved in, let me restate the question. Strike benefits were issued, were they not, to persons who provided services for the Airline Pilots Association during the course of the sympathy strike? State the question again. How did somebody become eligible to get strike benefits? How did they become eligible? Question, yeah, if they were a striking pilot. Further question down the road. Question, well, the documents that signed Gregory Pachinko say a stop payment on the last benefit check has been placed on checks to all that appeared to the attached list, close quote. Now, did you prepare a list that you provided to ALPA membership for purposes of having them stop payment on benefit checks? Answer, I previously stated that I had. I was providing the ALPA membership with the department with the information we had on scabs at the time. He goes on to say, a question, were there various lists that were published from time to time between March 4th, 1989 and June of 1990? Final list. Answer, there were almost daily updates to it. He goes on to say, for purposes of accounting for strike benefit checks, when checks were due out to a copy, the latest would be provided to all at the strike comm centers. Question. Well, assume for the sake of this question that it was an ALPA sympathy strike, which is our agreement. It is your opinion and view that individuals who completed training and flew revenue flights for Eastern as permanent new hire replacement pilots or scabs. By my personal definition, yes. Yes. So, on one hand, I again reiterate that the evidence doesn't show me to be a scab. The defendant leader says I'm not a scab by evidence, yet the courts took a diametrically opposed position. Another one of the defendants was a guy named J. Randolph Babbitt. Now, Mr. Babbitt was the president of the union at the time. One of his definitions or deposition statements was, are you aware of the fact that strike benefit checks had stopped payments issued on them after they were delivered to pilots? If the answer, if the situation where a pilot had returned to work, yes. Was the strike benefit a payment for a pilot not working for a period of time? Answer, a strike benefit is just what it is. A pilot is on strike and it is the amount of money given to him by other members to support him while he is withdrawing his services or her services. And these are just two of the many example deposition comments on my evidence. The defendant's attorneys were there, and the courts relied on the false statements made by the attorneys in reaching their conclusions. Another comment is the union voted to bring, it's called Article 8 charges against all strike breakers in accordance with ALPA Constitution and bylaws. I was never subjected to that. Says, whereas many of these pilots actually flew Eastern Airlines aircraft because of their conclusion on their preferential hiring recall list, while former striking pilots were denied this opportunity. and so forth and so on. Here's another chairman of the Eastern Union. Says he sent out a letter that says, it has been alleged that you have been flying. The stigma of having flown during a strike will live you forever. If you feel an error has been made in listing you as a pilot who has flown for the company, well, I never got this letter, nor would I have reasonably received it because I didn't meet the criteria. So using this information, the courts went on to conclude and this was before the Judge Edward B. Davis. He says that he agrees that pilot trainees are not permanent replacements. Moreover, ALPA contends that the district court's preliminary injunction satisfies the requirements of, well, one of the federal rules of civil procedure, and on and on. However, Judge Davis' decision was the second of his opinions on the status of trainees during the Eastern strike. Initially, he ruled that trainees were not permanent replacement pilots. And this was in a 1990 case. Edward B. Davis was the judge. One of the attorneys was James Lindsay. So Lindsay knew, one, the evidence that I had, and he knew, two, the case law on the subject. Judge Davis comes along and reverses his status on trainees in my case, took a diametrically opposed position. Now, the American legal system has, or judges have several basic guidelines to conduct themselves. One is a very old established principle called stare decisis. Stare decisis is defined as, once a court has answered a question, the same question in other cases must elicit the same response from the same court or lower courts in that jurisdiction. Well, Judge Davis didn't do it, nor did the 11th Circuit Court of Appeals. Judges have, or had at the time, the canons of judicial conduct. And I'll read to you a little bit from Professional Responsibility, written by Ronald Rotunda. Now, this book is a widely used legal ethics course, textbook, and Mr. Rotunda is one of the nation's foremost experts on the subject. Regarding the canons of judicial conduct, let's see. In the terminology, the 1980, we find in Professional Responsibility, the 1972 code used the term should in the canons in text, and as a consequence, some jurisdictions thought that should only expressed an aspirational standard. The 1990 code, now the 1990 code was applicable to the judicial conduct in my case. It started in 1991 and went through 2000. The 1990 code eliminates this confusion by using the term shall in the text and must appropriately. I'm going to read I'll read two of the canons that judges were supposed to comply with when reaching a decision in my case. Canon 2A provides that the judge shall comply with the law, which is defined to include not only court rules, but also statutes, constitutional provisions, and decisional law. Here we go again. One set of standards for one group, another set of standards for Joe Norman. And this was all in a relatively short period of time. Canon 3B2 places three main duties on judges. First, it states that a judge should be faithful to the law. And we just went over what the law is. It includes decisional law and constitutional provisions, statutes, and so forth. Now, remember that, because we're going to be talking about a petition for writ of mandamus later on down the road, when Judge William Hoovler just totally threw this out the window. But that sort of takes care of an overview of what happened. I'll just read a couple of brief excerpts from the 11th Circuit Court of Appeal decision in my case as to what the court believed and what was totally false. It talks about ALPA, and it's bringing union charges under the ALPA's Constitution against ALPA members who crossed the picket lines, individuals who were placed on this list of working pilots only upon receipt of 2 confirmed reports that they had crossed ALPA picket lines, and after being provided an opportunity to refute the allegations that they had crossed the picket lines to fly for Eastern. It's undisputed in this entire saga that I never flew for Eastern Airlines in my life. Nobody ever said I did. The lawyers knew the truth. They razzle-dazzled the courts, and the courts, for some reason, I have my opinions, went along with the falsehoods instead of the evidence that I produced and the commentary that I provided with the evidence produced. We've got judges abrogating the canons of conduct. We've got attorneys misrepresenting facts to the court by remaining silent. This is a problem. So we go down the road a little bit, and I decided, well, you know, this isn't right. And I began investigating how judicial misconduct is defined or handled. Well, I find one, that judges self-police. The procedures for filing judicial misconduct complaints, and your readers or listeners can just Google the term 28 U.S.C. 351 to 364. And the complaint form is, you can find it online, fill it out, and send it in. And it's reviewed by the chief judge. Now, 352 B2 says that, and I'll read this, after expeditiously reviewing a complaint under subsection A, the chief judge, by written order stating his or her reasons, may, here's the excuse, dismiss the complaint if it is directly related to the merits of a decision or procedural ruling. In other words, a federal judge can act in any inept, incompetent, corrupt manner they so choose without fear of any reprisals from anybody. And now this is appealable to a 3-judge panel at the Court of Appeals. The 3-judge panel is made up of fellow judges, and naturally they're not going to find one of their fellow judges in violation of misconduct allegations, because they might be the next one who's complained of. You know, it's kind of the old protect your buddy and he'll protect you at the proper time. And what's interesting, and I'm just going to read one comment by John Ashcroft, former U.S. Attorney General. He says, no country, certainly not the United States, is free of corruption, and no country should lecture others on how to eliminate it. I remain convinced that there is no more important area in the fight against corruption than the challenge for us within the law enforcement and justice sectors to keep our own houses clean. Corruption in the agencies charged with enforcing our laws not only threatens communities by allowing dangerous criminals to roam free. We must all, in our own countries, lead the fight to ensure integrity within our police and judicial systems. John Ashcroft, in remarks to the Second Global Forum on Fighting Corruption. Well, since my judicial misconduct complaints went nowhere, I decided that the proper thing to do was take it up with Congress. Certainly they should want to know what's going on in the courts. Well, Let me take a pause here and get some more information. I started a dialogue with my then Congressman Alan Boyd. Told him about the problem. This was back in 2003. In 2003, Lamar Smith, who was then chairman of the House Subcommittee on the Courts, July 23, 2003, announced that he and Steve Chabot were forming the Judicial Accountability Group. Turns out this is really a load of hot air. And I'll read the press release regarding it. Smith and Chabot formed Judicial Accountability Group. Congressman Lamar Smith and Congressman Steve Chabot today announced the formation of the House Working Group on Judicial Accountability. Representative Smith and Chabot co-serve as chairman of the group. Quote, this working group seeks to establish several goals. First, we want to educate members and the public about judicial abuse. Secondly, we will try to prevent judicial abuse. And third, we will support the nomination process for judges who will not substitute their own policy views for the law, says Representative Smith. The fact remains that the judiciary is a co-equal branch of the federal government. They are subject to checks and balances. Congress is right to evaluate them when they behave like unelected super legislatures, added Smith. Supreme Court Justice Louis Brandeis said, quote, sunshine is the best infectant. Noted Smith, our judicial system needs a little sunshine from time to time. Judicial activism occurs when judges exceed the authority given to them under Article 3 of the Constitution. When judges substitute their own political views for the law, the ramifications can be felt by communities across our nation, said Representative Chabot. And it goes on to list members of this Judicial Accountability Group. Well, you know, a lot of fanfare was made over this this group. So, being aware of it, I contact my Congressman Alan Boyd, now former Congressman Alan Boyd. And he writes a letter to the Honorable Lamar Smith, Chairman of the Judiciary Subcommittee, Courts, the Internet, and Intellectual Property. Dear Mr. Chairman, it reads, having recently read about the formation of the House Working Group on Judicial Accountability, which you co-share with Representative Chabot, I was prompted to send this correspondence today. I write to you on behalf of a constituent of mine who lives in Tallahassee, Florida, whom I feel has been grievously wronged through judicial conduct. My constituent is Mr. Joseph S. Norman II. I will not address the specifics of Mr. Norman's situation, but have included with this letter an overview provided with Mr. Norman. He has sought relief for his grievance through the federal court system and has been stymied at every turn. From his own experiences, Mr. Norman believes that the odds are not good when a citizen who feels he has been wrong has to ask a judicial council to find fault with one of its own. Mr. Chairman, Mr. Norman's request, which I endorse, is fairly simple, but will require someone in a position of authority, such as yourself, who is willing to hear and understand the devastating effect caused to his career and life by the federal bench. He asked that he be able to participate in any hearings or investigations that address the current methodology of reviewing judicial misconduct complaints. Please accept my thanks for your sincere consideration of this request to help Mr. Norman. Your positive response will be the first step in helping to restore his faith in the judicial branch of the United States government. Sincerely, F. Alan Boyd, Jr., Member of Congress. Well, needless to say, I never got a reply to this. However, what's interesting is that Mr. Lamar Smith is now chairman of the House Judiciary Committee. As of right now, he's the man. And I naturally wrote him a letter and got no reply. But what's interesting, and it kind of further exemplifies the problem citizens have in dealing with Congress and our government. This comes from the Congressional Oversight Manual. This one's dated June 10th of 2011 and comes out every 6 months with any revisions. At one point later in my attempt to get justice, I attempted to have 18 USC 3332 enforced. Similar language is found in the U.S. Attorney Criminal Resource Manuals, Section 159, but I'll go into that in a few minutes. But 3332 is pretty clear, established by Congress and codified. And on the summary page of the Congressional Oversight Manual, it observes, quote, "Today's lawmakers and congressional aides, as well as commentators and scholars, recognize that Congress work ideally should not end when it passes legislation. Oversight is an integral way to make sure that the laws work and are being administered in an effective, efficient, and economical manner. In light of this destination, oversight can be viewed as one of Congress' principal responsibilities as it grapples with the complexities of the 21st century." Now, we've got Congressman Boyd tried to help me out, trying to deal with the subcommittee on the courts and got nowhere. So eventually, Mr. Boyd lost his election, and I diligently and immediately began a dialogue with my current member of Congress, Steve Sutherland. And I made clear all I wanted was to have the law enforced. And I sent many communications to him telling him what law I wanted enforced, the law and getting it enforced, and I never got really a reply back discussing it. And I eventually gave up on that situation. I even asked if he had any friends on the Judiciary Committee. Two were mentioned. One of them was Sandy Adams, represents the area of around Oviedo, Florida, and Dennis Ross, who represents the area around Lakeland, Florida. I don't know what to do. I just can't get Congress to do its job. I'll talk to you a little bit about trying to have 18 USC 3332 enforced. First, I'll read it to you so that you'll understand the language, and you can just Google the term if you want to verify it. It's 18 USC 3332, and it relates to grand juries. It says, "It shall be the duty of each grand jury impaneled within any judicial district to inquire into offenses against the criminal laws of the United States alleged to have been committed within the district. Such alleged offenses may be brought to the attention of the grand jury by the court or by an attorney appearing on behalf of the United States for the presentation of evidence. Any such attorney receiving information concerning an alleged offense from any other person shall, if requested by other person, inform the grand jury of such alleged offense, the identity of other such person, and such attorney's action or recommendation." Well, if I were sitting on a grand jury and I was told about the defendant attorney misconduct or conduct in my civil case and the judicial conduct in the case, I could fairly easily conclude there must be some sort of corruption going on. Both the attorneys and judges freely abrogated either their canons of conduct or model code in the case of lawyers. Search for truth was just not a relevant concern. So that takes care of 3332. Now, in the U.S. Attorney Criminal Resource Manual, we find language talking about impaneling grand juries, and the pertinent part, it says, "It is incumbent upon any such government attorney to whom it is reported that a federal offense was committed within the district, if the source of information so requests, to refer the information to the special grand jury, naming the source and appraising the jury of the attorney's action or recommendation regarding the information." The U.S. Attorney Manual mandates it. The federal law mandates it, yet they won't do it. And I'm going to read from a United States Attorney's Office dated November 1, 2011 press release. So the title of it is "Former FBI Agent Convicted in Manhattan Federal Court of Making False Statements." The pertinent sentence in this press release, it says, "Law enforcement agents who break the law dishonor their fellow officers, disservice the public, and must be held to account." Well, I've got clearly the U.S. Attorney in Miami who won't follow the law. The position must be that he's dishonoring his fellow officers, providing a disservice to the public, and must be held into account. Well, realizing the U.S. Attorney wasn't going to go too far, I filed a petition for writ of mandamus. Petition for writ of mandamus is asking the court to compel compliance with, in my case, a federal law. The case was assigned to then 85-year-old federal Judge William Hoovler. Judge Hoovler had a stroke and apparently had some other issues, but he was still on the bench. Federal judge is called an Article III judge, and they can stay on the bench for life as long as they act in good behavior. Now, amazingly, in 200 years of existence, nobody has taken time to define bad behavior for federal judges. Furthermore, in 1934, Congress passed what's called the Rules Enabling Act. Now, the Rules Enabling Act allows the federal judiciary to present suggested rules changes and law to Congress for approval. Now, Congress doesn't have to approve these suggested changes, they have to reject them. In other words, what the federal judiciary wants to do pretty much goes unimpeded. And as luck would have it, one of their first acts was the adoption of summary judgment. That was like in 1937, 1938. And summary judgment allows a federal judge to determine, in his or her opinion, there are no triable issues and terminate the proceedings. They just grant summary judgment on the spot. Well, I can't think of a greater or a better conduct guideline for corruption. You got a guy who's got a lifetime appointment. He can have complaints against him dismissed if they're directly related to the merits of a decision. I'm just dumbfounded that what I have discovered has happened in the United States of America. I mean, we've got men and women defending the rights of our citizens, and one of our rights is to a judiciary or to a venue that mediates disputes and determines if harm has been done and to punish those that have caused the harm. Well, it's just way out of control. The judges act as they want. There's no oversight. Congress could care less, and the problem continues. I mean, we've got an Attorney General Holder who's had a lot to say in world speeches about ours being a nation of law and us having the rule of law. I can't begin to get codified law, 18 U.S.C. 3332 enforced. So we've got quite a conflict. It tells me a lot about the credibility and integrity of Mr. Holder. Now, let's go back to 3332. I filed this petition for writ of mandamus, and in the writ, I made clear one, that the U.S. Attorney, in fact, has no discretion. And on April 26, 1985, a federal judge in the Southern District of New York addressed the language in 3332, and he concluded, and I quote, "The legislative history of 3332 suggests that Congress envisioned the United States Attorney's Office as the primary channel of information to the grand jury. Since the United States Attorney has been requested to present certain information to the grand jury, he must do so. I will not relieve him of a duty which Congress has seen fit to impose. 18 U.S.C. 3332 imposes a plainly defined and preemptory duty on the part of a United States attorney to present plaintiffs' information concerning the alleged wrongdoing of the other defendants to the grand jury. That's a federal judge's opinion on 3332. Well, I go along, I file my petition for writ of mandamus, state this leading decision, and talk about the history of 3332, which came from the 1970 Organized Crime Act. And that's kind of a long, boring act, but the general drift is that citizens are entitled to the right of access to a grand jury. Now, 3332, I've read you the language, and I'll just read you a couple of comments on the Supreme Court decision, United States Supreme Court decision, on compliance with codified law. On June 26, 2006, an Arlington School District Board of Education petitioner versus Pearl Murphy et var. Wrote, this is the Supreme Court writing, "We have stated time and again, the courts must presume that a legislature says in a statute what it means and means in a statute what it says." Connecticut Bank v. Germain, so forth. When the statutory, quote, language is plain, the sole function of the courts, at least where the deposed required by the text is not absurd, is to enforce it according to its terms. So we've got a law the Supreme Court says is to be enforced according to its terms, or somebody needs to say why it's absurd or is not clear. Well, old Judge Hoovler apparently couldn't grasp these concepts. And, I included many depositions and other documents trying to get the point across, but poor old boy just couldn't rise to the occasion. So, with that in mind, I just kind of began simultaneously a dialogue with the Office of Professional Responsibility. Now, the Office of Professional Responsibility at the Department of Justice oversees U.S. attorney conduct. And I started, many, many years ago, communicated with different counsels to the Office of Professional Responsibility, laid out the law. I never got anywhere. In fact, they've reached to the point that they don't even respond to my letters. The concept of access to a grand jury has been commented on many times. This is from I've got one comment that's particularly good about the grand jury basically being a fourth branch of government. Oh, the grand jury is independent of judicial, legislative, and executive branches of government. In 1992, Supreme Court Justice Antonin Scalia explained that the grand jury is not part of the three branches of government set forth in the Constitution. Judge Scalia also says the grand jury is an institution separate from the courts, whose functioning the courts do not preside. It is perfectly reasonable to characterize the grand jury as the fourth branch of government. It goes on, the grand jury is mentioned in the Bill of Rights, but not in the body of the Constitution. It has been textually assigned, therefore, to any of the three branches. No, it has not been textually assigned, therefore, to any of the branches described in the first three articles. In fact, the whole theory of its function is that it belongs to no branch of the institutional government, serving as a kind of buffer or referee between the government and the people. The grand jury, although the grand jury normally operates, of course, in the courthouse and under judicial auspices, its institutional relationship with the judicial branch has traditionally been, so to speak, at arm's length. Judges' direct involvement in the function of the grand jury has generally been confined to the constitutive one of calling the grand juries together and administering their oaths of office. The grand jury classically is meant to be an independent check on the ability of government to bring charges against individuals. And you know, I could talk on and on about this, but basically the grand jury is supposed to be on its own, left alone, and allowed to go about its business. Well, with all of this having been said about the grand jury, one of the biggest ironies in my life occurred early this year. I live in Leon County, Florida, and I got summoned for jury duty. And there are probably 150, 200 people sitting in a room. The first order of business was a name calling of about 30, 35 people. And they said, would you folks follow me? So we got the elevators and ride up to the third floor and go into an empty courtroom. And I'm told, or we were all told, congratulations, you're our new grand jury. I currently sit on the grand jury in Leon County, Florida. The first order of business was to present us a document called the 30 Florida Grand Jury Handbook. That handbook goes into the history of the grand jury, its importance to society, and what our authorities are. Well, most noteworthy in the entire document stated in part, and I'll quote, the grand jury, in addition to the duty of formally indicting those charged with crime, has the further important duty of making investigations on its own initiative, which will report as presentment. This duty permits investigations of how public officials are conducting their offices and discharging their public trust. The grand jury may indict as to whether public institutions are being properly administered and conducted. It has the power to inspect those institutions and, if necessary, may call before the grand jury those in charge of the operations of public institutions, as well as any other person who has information and can testify concerning them. If the grand jury finds that an unlawful, improper, or corrupt condition exists, it may recommend a remedy. Well, it dawns on me that in fact, about all of the misconduct at the district court level was perpetrated by members of the Florida bar. To practice law in Florida, you have to be a member of the bar. And I'll just read you some rules regulating the Florida bar that were clearly abrogated. Rule 3.3, candor toward the tribunal. False evidence. A lawyer shall not knowingly make a false statement of material fact or law to a tribunal. Fail to disclose a material fact to a tribunal when disclosure is necessary to avoid assisting a criminal or fraudulent act by the client. Permit any witness, including a criminal defendant, to offer testimony or other evidence that the lawyer knows to be false. A lawyer may not offer testimony that the lawyer knows to be false in the form of a narrative unless so ordered by the tribunal. If a lawyer has offered material evidence and thereafter comes to know the falsity, the lawyer shall take remedial measures. Well, I filed attorney misconduct complaints about these lawyers with the Florida bar, outlining what happened, and the Florida bar took no action. Well, the Florida bar is headquartered here in Tallahassee. So it seemed to me that by not taking any action, and I'll just read a definition. It comes from Black's Law Dictionary, 5th edition. Black's Law Dictionary is one of the standard, or the standard for legal terminology. It'll take me just a second here. I should have. Now, I'll read this definition, and I believe it's applicable. Accessory after the fact. A person, knowing a felony to have been committed by another, receives, relieves, comforts, or assists the felon in order to enable him to escape from punishment or the like. Well, fraud, it's pretty clear in my opinion that the attorneys representing the defendants are guilty of perjury and fraud. So that would make the Florida bar accessories after the fact, since I made them aware of the criminal act, and they failed to take any action. They assisted the defendants. Okay, so I'm thinking, well, now I'm in the grand jury. I want to try to indict the Florida bar, and in my thinking, I complained about one or more attorneys. The Florida bar dismissed all complaints. In fact, I appealed the initial decisions, and the Florida bar continued to shield the defendants from their wrongdoing. So I'm thinking, well, we have numerous predicate acts, and that qualifies under the Florida RICO law. Now, the Florida RICO law talks about acts within 5 years. It doesn't say the previous 5 years. It's within 5 years. So I'm thinking, well, there's no statute of limitations that's run on this, and I believe I can indict the Florida bar as a criminal enterprise. Well, as a grand juror, I'm also I'm about to get too much paperwork here. Let me take a quick organization break. But as a Florida grand jury, I remember I have 2 documents that provide guidance on what we can do and what we're required to do. And I'll read Florida Statute 905.20. It says, quote, duty of a grand juror having knowledge of offense. A grand juror who knows or has reason to believe that an indictable offense triable within the county has committed shall report the information to the grand jury and may be sworn as a witness in the investigation. Now, I've described how, in my opinion, the Florida bar can be indicted as a criminal enterprise. I told the state attorney my intention. He says, summarize what you want to do and send it to me. Well, I did. Talked it over with the foreperson of the grand jury, and I first gave this talk to the foreperson, which is the procedure required, and he talked to the state attorney. In fact, one day I'm walking up to the 2 of them when they were apparently talking about my situation, and State Attorney Meg says, the Florida bar. What is the Florida bar? I said, well, it's an enterprise for purposes of the Florida RICO Act. He says. So I walk on. And then I'm told, to get a document together for him to review, which I did. At the next grand jury meeting, my document was about 70 pages long, describing in some detail my logic in the law. Well, at the next meeting, he says, Mr. Norman, will you leave the room? I leave the room. In 14 minutes, he summarizes my entire document, reads the grand jury the law, gives them time to discuss it and vote in 14 minutes. Then he comes and gets me and he says, well, you didn't get the required number of votes. All right. Well, there's a protest procedure to invite the presiding judge to mediate issues between myself and the state attorney. I filed a protest, gave it to the foreperson on September 27th of this year. And I'll review a pertinent part of the Florida Grand Jury Handbook that I'm relying on. It says the grand jury, in addition to the duty of formally indicting those charged with crimes, has the further important duty of making investigations on its own initiative, which it will report as a presentment. This duty permits investigation of how public officials are conducting their offices and discharging their public trust. The grand jury may investigate as to whether institutions are being properly administered and conducted. It has the power to inspect those institutions, and if necessary, may call before the grand jury those in charge of the operations of the public institutions, as well as any other person who has information and can testify concerning them. If the grand jury finds that an unlawful, improper, or corrupt condition exists, it may recommend a remedy. Now, in this whole process, there's nothing that requires me to say squat to the state attorney. The state attorney is strictly on board to give legal advice. He's not there to do anything else. The law requires me to make the presentation to the grand jury. I have the authority according to law, but we've got a state attorney that's not going to let it happen. Since this letter went to the judge, we've had 2 grand jury meetings, and absolutely no comment has been made about my letter. We have one more in late November, and it's my supposition that they're just going to let it die and shirk their duties. Personally, I think they're interfering with the grand jury, and there must be some law that punishes those that do such. But, you know, this is Florida. For 9 years, Florida has been on the annual American Tort Reform Association list of judicial hellholes. Now I ask you, if you were the CEO of a corporation looking to relocate, would you move to a judicial hellhole? Florida needs jobs. I mean, it's unbelievable what goes on. This is a fine example. This $50 million building. We've got problems, and nobody wants to look at them. You know, I contend the American taxpayer is funding the biggest cash for clunkers program in the history of the world. Our tax money pays the salaries of the members of the Department of Justice, the clunkers, the 11th U.S. Circuit, the clunkers, then the legislative branch of government, more clunkers. It's frustrating. On one hand, we're supposedly a nation of law that has the rule of law. On the other hand, it's merely a fallacy. And that's about all I have to say.